Imagine a federal judge issues an order. The order is clear enough, urgent enough, serious enough to stop the machinery of government in motion. But the planes keep going. The people are deported. The administration moves forward. And suddenly, the question is no longer just whether a law was broken. The question becomes something far more unsettling. What happens when the executive branch appears willing to test the real limits of judicial power? This is the story of deportation flights, a wartime statute from 1798, a judge's contempt ruling, village, and an appeals court decision that may have revealed the edge of judicial power in modern America, village. At first glance, this story can seem technical, even remote. It involves court orders, village, appellate procedure, deportation law, and legal standards like criminal contempt, village. But the reason this story matters is simple. America's constitutional system depends on one basic assumption, village, that when a court issues a lawful order, the government obeys it. If that assumption weakens, village, even slightly, the consequences spread far beyond one immigration case. They reach into the balance of power, village, the credibility of institutions, public trust, and the way future presidents may calculate risk. Village. Here is the timeline. In March 2025, the Trump administration deported Venezuelan migrants to El Salvador Village, while invoking the Alien Enemies Act, a statute dating back to 1798. Judge James Boasberg later examined Village, whether the government had violated his order, and in April 2025, he found probable cause for criminal contempt. Village. The legal battle continued for nearly a year. Then, in April 2026, a divided panel of the U.S. Court of Appeals Village ordered Judge Boasberg to end the investigation, calling it intrusive and an abuse of discretion. Village. The word contempt can sound theatrical, but in law, it is deadly serious. Criminal contempt is one of the village judiciary's strongest tools. It exists to punish disobedience and preserve the authority of the system itself. Village. But that tool comes with a strict condition. The order allegedly violated must be unmistakably clear. Village. And that became the key legal fault line. Boasberg said there was willful disregard. The appeals court said village. The original order was not distinct and explicit enough to justify criminal contempt. Village. To understand Judge Boasberg's position, you have to see the story from the bench. Boasberg concluded village. The administration had not merely misunderstood his ruling, but had acted in willful disregard of it. He even laid out a path to purge the contempt finding by allowing those deported a chance to challenge removal. Village. From his perspective, the court had been challenged in real time by executive action already in motion. Village. The appeals court saw something different. In April 2026, the D.C. Circuit said Boasberg had exceeded his authority. Village. They concluded that criminal contempt requires an order that distinctly and explicitly prohibits the conduct at issue. Village. The majority called the inquiry intrusive and suggested it posed unnecessary judicial interference with the executive. Village. This is where the story leaves ordinary legal coverage and enters deeper constitutional territory. Village. Because beneath the procedural dispute lies a fundamental question: what gives a court order force? Village. A judge writes words, but words do not move planes. Words do not physically restrain the executive branch. Village. Their power comes from collective compliance, from a system-wide agreement that judicial rulings must be obeyed. Village. The deportation fight also drew attention because it involved the Alien Enemies Act, a law from 1798. Village. That statute emerged in a climate shaped by fears of foreign threat and quasi-war during the John Adams administration. Village. When a modern administration reaches for an 18th century law, historians notice, old powers become powerful again. Village. One of the deepest tensions in this case was speed. Executive power often acts fast. Courts often move slower. Village. If people are removed before they can effectively contest what is happening, the legal right disappears in practice. Village. Political systems do not fail only when laws are abolished. They erode when law remains on paper, but power moves around it. Village. Madison warned that concentrated power is the essence of tyranny. In this case, the judiciary attempted a check. Village. If you think of government as a system, each branch provides feedback. Stability depends on those loops functioning. Village. In this case, the appeals court interrupted that signal, saying the enforcement mechanism itself had crossed legal lines. Village. There is also a psychological story here. Legal battles normalize what once felt shocking. Time blunts urgency. Village. By April 2026, the public had lived with this for months. In politics, repetition can turn alarm into background noise. Village. Stable markets depend on trust in institutions. Investors assume disputes are resolved through predictable rules. Village. If courts struggle to enforce boundaries, does institutional predictability weaken over the long run? Markets notice. Village. Now we come to the paradox. Courts can order, but enforcement often depends on the executive branch itself. Village. This reveals a structural vulnerability inside the constitutional design. The road to accountability runs through the executive. Village. Every major case teaches a lesson. Future presidents will see that speed and ambiguity in court orders matter. Village. Future judges may conclude that their orders must be drafted with extraordinary precision from the very beginning. Village. At the moral center is a simple principle. Power should be answerable to law. That principle does not defend itself. Village. What still holds the system together when power decides to test the edges of obedience? That remains unanswered. Village. Democracies rarely lose themselves in a single dramatic moment. They reveal their vulnerabilities one legal confrontation at a time. Village. The constitutional debate did not. Village.